It's good, the table's long enough too. Perfect.
Okay, you're all set.
Good evening, everyone, to the June 29th Town of Newcastle work session. The first, I would say, live or virtually or pseudo-live work session that we've had in some time. So welcome aboard to our two fans in the audience. You can't see them, but they're excited to be here. No announcements for the work session. I just do want to say very quickly that everyone is probably aware now what happened at the Bagel Emporium. Ultimately, we all wish for the well-being of the gentleman who was hurt, as well as his family in the recovery. I just wanted to say thank you to all our first responders, and we don't always say it. I know everyone knows it and thinks it, but our fire department, our EMS, certainly our police too, but across the board, they do an amazing job, and they're doing it because they care for the community and putting themselves part of the dangerous way. So I'm very grateful for their service and certainly taking that call and responding as they did. That being said, I'm going to pass it over to Joe. Actually, you know what I didn't do? I don't think did I take a motion to open it? I don't think I did. So I'll move to open. Anyone?
So moved. Second.
All in favor? All right. I'll just open a share.
Okay, so the first thing on our agenda is the form-based code schedule discussion. We have a tentative schedule, draft schedule for the next 5 months for tasks concerning the form-based code, going from the work session on the proposed zoning legislation, which is going to be July 27th, straight through to potentially adoption of the legislation on November 23rd of 21. Do we want to go, should I go through each one of these or?
Yes, well, yes.
Okay.
Right, so it's a tentative work session scheduled for the proposed legislation for Tuesday, July 27th. Then a work session on the draft FGEIS, which the consultants are preparing consultation with town staff. That would be discussed on Tuesday, August 10th. And then this all depended on the discussions, the town board would consider a resolution at its August 30th meeting to accept the FGEIS as complete.
Which is not a Tuesday.
You're right, it's a Monday.
Right, it's right before school starts.
Good catch, thank you.
Right, so those are the first three items. The work session on the proposed zoning legislation that's being redrafted and considered based upon comments at prior work sessions. Then a work session on the draft FGEIS on August 10th, and then consideration to accept the FGEIS as complete on Monday, August 30th, which is of course dependent upon the work session being held on August 10th. After that, the board will then be scheduling community engagement sessions on those two documents, the FGEIS and the zoning legislation, for Wednesday, September 22nd and Thursday, September 23rd. I don't have the time for those.
No, one is going to be in the morning, one's going to be in the evening, and we're hoping that they're actually going to be held at the Chapel Performing Arts Center. So there'll be a further update on that as well.
And this is a penciled schedule.
Yes,
so
this is absolutely.
Right. This is to put the steps down on the calendar, put tentative dates out there, recognizing that it's going to be reactive to the board's comments and the process as it evolves.
Wait, why are we doing that Tuesday? 21st?
Which
Why are we
The
doing
first community
Wednesday
engagement
and
section, which is scheduled for Wednesday the 22nd. Is that the morning session?
Why are we
it's not a
doing?
board meeting, it's just an engagement. We're not going to do it at the same time.
We're going to have a board meeting on
town board
Tuesday.
meeting, separate apart from.
We're doing them separate. To do 2 different times.
Yeah, so one's going to be in the
Times a
morning,
day.
one's going to be the evening. I think I had a note on that. Let me just see if I can find it.
And so if people can't come that week to the community engagement session for some reason, that's it?
There's two for it. We've done plenty for the FDGIS.
Well, the
DGIS.
same one's one night and then the next morning.
So I don't even think.
Right, actually the 22nd, I'm sorry, is going to be an evening session, and the 23rd is going to be a day session.
Mm-hmm.
You know, my understanding, and tell me if I'm wrong, we're not required to have these engagement sessions at all. But
No.
we're doing it, again, to have more opportunities. And to be clear to anyone's listening at home, this has expanded over years in engagement sessions to where we are now, and we're going to continue to have more engagement sessions.
And then there's a couple of public hearings that follow those engagement sessions on the legislation itself. You're right, secret does not require any subsequent, the secret public engagements with the DGIS process, not the FGEIS
So to
process.
be clear, it's not just these 2 evening and morning sessions that will be the opportunities for people to share their thoughts and be heard. There'll be other opportunities throughout the process. These are just specifically for that sole purpose.
Well, but those are the only ones on the finding statement, because it looks like you have scheduled here for the town board to adopt the finding statement in the middle of October.
Okay.
The public hearing is 2 weeks later.
Well, on the legislation, right. So let me just go, maybe I'll go through the rest of the schedule and then. So then so after you have these community engagement sessions, right, you will have accepted the FGEIS as complete. You'll have a work session on the draft finding statement. The finding statement is what follows the adoption of the FGEIS. That's for September 28th. And then on October 5th, you have a scheduled work session on the proposed zoning legislation. And then for October 12th, the schedule proposes consideration of a town board resolution adopting the finding statement and scheduling a public hearing on the legislation. And then on October 26th, you would hold the public hearing on the proposed legislation, anticipating that it would be continued to Wednesday, November 10th. And then with consideration of a town board resolution to adopt the legislation at your Tuesday, November 23rd board meeting. So that takes you through the processes of the FGEIS, the finding statement, and the legislation. Those are the 3 key procedural steps.
So we're not having any public engagement sessions before the town board is supposed to adopt the FGEIS as complete. Is that correct?
That's correct.
We've had ample opportunity, and the consultants are going to respond with the answers to all the issues that have been raised, and we're going to have an opportunity to review it. We've already given the public the opportunity to for lack of a better term, digest and analyze and throw out their issues and questions. So it's an ongoing process, and we are moving it forward. At some point, we have to come to a final point.
Well, right, but let's just say, for argument's sake, that the response that they bring us back is terrible. Are we saying that we don't, or the public has further questions, or there are things that people say they don't think are complete? We're not giving anybody an opportunity to say that. I know we had some public sessions on the draft generic environmental impact statement, but we're not having any for the final.
So secret does allow for and requires the 10-day comment period after the FGEIS is accepted, where people can make public comments, and that's before the finding statement. So after the FGEIS is adopted and before the finding statement, there is the opportunity for the public to provide written comments on the FGEIS.
But it's already been complete, so it doesn't really,
Because
the
that
comments
then,
are like, thanks.
well, that then informs the finding statement.
I think we've given ample opportunity, and we'll continue to give more opportunity for the public to be engaged. And I have no doubt there will be people, no matter what is done, it will be wrong. No matter what is done, it won't be what they want. And you can't make everyone happy. There's always, no matter what your decision, and not talking about the form-based code in general, there's people who support it,
I
there's people
agree.
who won't support it. So at some point, as a legislative body, we need to move the ball forward and still providing opportunity to be heard.
Right.
And again, I can't stress enough, this has gone from a much shorter schedule to an exponentially larger schedule with much more opportunities for engagement, and there'll be continued opportunities for engagement because we want to hear from people, but we also have to move this forward, in my opinion, because it's not as if it's stagnancy. They're doing their job, the consultants, they're providing us the information that we want. People can submit questions or issues as Dick just mentioned, and whether or not they approve of or agree with the GEIS, they'll still have opportunities to engage us in question and provide comments on further public hearings before we actually get to the form-based code. So I'm comfortable with it, and I'm comfortable with the community's opportunity to remain involved.
I feel like we need that public hearing. I mean, look, the consultants did such a bad job the first time that they had so many comments they had to answer that we had to pay them more money, okay? $100,000 more. So I personally don't have any view that what they are gonna give us is gonna be complete. I feel like, I mean, let's be honest, they did a terrible job the first time, and I'm pretty skeptical that what is gonna be in there is gonna be complete, even though I know Sabrina and staff are gonna spend a lot of time looking at it. I feel like not to let the public, who they gave us so many comments the first time, to just say, thanks for your comments, you don't get to really opine on any of the answers here, is a big mistake.
So my very short brief response is, I don't think they're as terrible as you said they were. There was things that we wanted to see further. That is their job. They are going to analyze those things further, but at some point, this is not a perpetuity back and forth. There's opportunity to be heard, there's opportunity to engage, there's opportunity for us to respond, and there's opportunity to find what works. And this is the body that's going to make that decision. So I disagree with your statement in terms of them doing a terrible job. Ultimately, you, like I, voted to support them and give them this opportunity. I'll say lastly again, we've given ample chances for people to be heard because they want people to be heard. They expanded it greatly, and we'll continue to give them that opportunity to be heard. And ultimately, I know we're going to disagree. It is what it is, but we're going to keep on moving forward.
Are we gonna let people speak at these work sessions?
We're going to be as consistent as we were in the past. I mean,
Is that a yes or no?
So we'll see what happens, but generally speaking, the answer is we do not have work session comments because we're not having each public session, each town board work session as a public meeting. So the answer is we're going to do what we did with every other proceeding, which is consistent here, and there will be ample opportunity to be heard. So you're not going to lock me into saying something. We're going to give people an opportunity to speak every time.
I'm just trying to understand, because I feel like
there's nothing. I don't think there's really anything. I think it's pretty clear. It's consistent. It's consistent.
it's clear that we're not gonna let people opine, have any input on the FGEIS before it's adopted.
So I appreciate your position. I disagree.
But I'm looking at the schedule.
So I appreciate your position. You can say that. That's terrific. But I disagree. I think there's ample opportunity, and we're going to move forward. So.
Okay. So.
Oh, somebody is saying.
But we don't do.
No, this is not a public forum right now in terms of.
So we're not
back and
here.
forth. So go ahead.
So then the next step, then we would just confirm these dates and let's put
Outrageous.
them on the town's website, and we'll provide them to the consultants and the staff, and we'll be working to provide a draft to the town board on the FGEIS at the end of July. And we're working with staff and the consultants, and we're getting drafts of chapters now, so that we're working on to make sure you have as complete an FGEIS as we believe is appropriate and available.
And I can't stress enough again, this is a temporary schedule. It's not an ink. Things
Right.
change all the time.
Why can't the public at the next town board meeting give you their input as to whether or not the schedule is satisfactory? After 15 months of not being in town hall.
Warren, I appreciate your comments. Certainly can send an email to the town board. I think it's pretty clear what I just said. We're moving forward. This is not a schedule that has to be approved by everyone in the community. I appreciate your concern. You're more than welcome to stay involved. I'm sure you will stay involved. And it speaks for itself, but it will adapt and it will potentially change as needed.
I just think after the last 15 months in this process, Jeremy, respectfully, I think it's kind of tone deaf that this is the way you're proceeding. And I say this to somebody, I'm not saying agree, disagree with the form-based code. I think you're making a process mistake as a board with the town by going this way.
Thank you, Warren. I appreciate that. All right. Is that it? We have-
Next on the agenda is the Indian Brook Croton Forge Watershed Overlay Zone. Sabrina, can you sort of update the board as to where we are with this and what actions they may need to take going forward? You're unmuted.
Sure. Thank you, Jill. In 2017, the town board had approved a joint application between the Village of Croton-on-Hudson, the village and the town of Ossining, the town of Cortland, and the town of Newcastle to submit an application to look at a watershed overlay zone and update the 2008 Croton Gorge Indian Brook Watershed Protection Plan. That plan was produced by the county back in 2008. It had been some time, and the communities had all gotten together and thought it would be a good idea to work together and see if we could obtain some monies to update and focus future efforts to protect that watershed. The group was led by the town of Cortland, and we did not end up getting community or monies from the consolidated funding application. Rather, we submitted a pared down proposal, a working group consisting of representatives from each of those municipalities. We assisted Cortland, mainly the lead, in submitting an application to the state to obtain monies to examine a 5-based community watershed overlay protection zone. So if you folks have gotten updates from time to time, I provided you with a memo updating the most recent activity, and the group led an RFP for a consultant to help us do the watershed overlay protection zone, where the consultant will look at all of the municipalities' regulations, look at the geographic information systems databases, and come up with strengthened policies to further enhance a watershed protection overlay zone. This is for your information. The town of Cortland on July 20th will be entering into an agreement with Weston and Sampson as the consultant. They were the vetted consultant by all 5 communities and the municipal representatives. And I didn't want to move forward without you guys having an opportunity to endorse this process.
Well, I want to first say thank you, Ed. It's an important process. In some way, we've been discussing this for a long time, this overlay. It may have predated us, I don't recall if it did, but it's an important step forward. I'm really grateful that we wrapped this and ran with it.
Thank you. Sabrina, do you need something formal from the board?
It doesn't have to be formal. It doesn't have to be formal unless the board wants to, issue a resolution in support of moving forward. You can, but it's not required at this point.
Discuss that amongst ourselves.
Yeah, I mean, I don't think the board has any issue with doing a resolution. I don't know that it was included in our packet for tonight. I don't know that it needs to be. If you want to write something out and submit it to Lauren or to me, just so we can take and circulate it to the group, that's fine.
I'm happy to do that.
Yeah, it's not that important. If we don't need it,
yeah, I mean, it's fine.
You don't need it. Again, this is really for your information so that you know that it's moving
you don't
forward.
need to do extra work just for the sake of doing work.
Yeah, fine.
Thank you.
That's
Okay.
great. I'm excited that there's progress.
Yeah, Lauren, can you just indicate in the minutes that the town board approves and
Is in support of.
Yeah, is in support of Weston and Sampson for the project. Thank you. Great. Okay, and that's all you need from us?
That is all. I didn't know if you wanted to confirm the AMI or not.
Yeah, sure, absolutely.
So as you know, we've had discussions regarding additional work that the consultant team working on the FGEIS is undertaking. One of the areas was examination of affordability in relation to the height of buildings. We had previous conversations where the objective was to examine 2 different levels of the area median income as dictated by Westchester County. Typically, the county, the 2 thresholds that are examined are 30% AMI and 60% AMI. Anything lower than 30% really doesn't get us anywhere. Anything greater than 60% really doesn't help us on the other end. So the consultant group, as they're conducting further analysis in relation to affordability and building height and, the market scan aspects of the form-based code, they wanted the town board to confirm that 30% and 60% were the 2 AMIs that they wanted to compare.
All right, resounding yes.
That's it. So unless anybody,
resounding head shakes yes.
okay, because I'm not.
Sabrina, are there any other options we should be considering?
I don't believe so. I truly believe that 30 and 60, that was my recommendation in speaking with the consultant team. They agreed with the 30 and 60%. It's really how the market operates when you're implementing affordable housing. The regulations usually relate to 30%. They stay silent on 60%. 60% AMI units are provided as a bonus, if you will, from a developer's perspective. But if we were to look at 80%, it really doesn't help us achieve our affordability goals as a community. If we look at 20%, then we're really not consistent with the county and the way that they examine the affordability requirements. So the 30 and the 60 were my recommendation, and I'm just asking I'm asking you to make sure that you're in agreement with my recommendation so that I can confirm that with the consultant team.
Right.
I think that's a yes.
Okay, great.
Thank you.
Sure, yeah.
Thank
all
you,
I
Sabrina, I
have to
appreciate it. All right,
Right.
Sabrina.
Good night, everyone.
night, thank you. Okay.
And I provided everyone a handout for a PowerPoint presentation that she was going to provide for us on this next
Thank
topic.
you.
Did you ever think, Drew, you were doing a PowerPoint presentation on marijuana?
Cannabis.
Cannabis.
This is
Let's clean it up, okay?
this is probably like the 5th time I've done a MRTA presentation. But this presentation is modified to specifically focus on things that the town board mentioned last time we talked about the MRTA. I did not have a PowerPoint at that point, so I thought it would be valuable to go back and highlight some key aspects of the MRTA and then also address some of your questions. And then we can talk about next steps going forward. Also, I can't get over how cool this is that I'm here and you guys are in person and now I'm going to show a PowerPoint. I can't get over it. So let me pull it up on the screen. Hold on.
I still see you.
Still see you.
And your slides.
Yep. And let me just, oops.
Yes.
Awesome.
Bear with me. I hit too many buttons.
Like the paparazzi over here.
Yeah.
He just wants it.
Okay.
He thinks it's cool
Can-
and just, you know.
Can everyone see the PowerPoint?
We can.
Yeah.
Okay. So we're talking about the MRTA. We talked about this probably a couple months, maybe like a month ago at this point. Just want to remind everyone that the MRTA, the Marijuana Regulation and Taxation Act, was signed by Governor Cuomo on March 31st, 2021. While it's called the Marijuana Regulation and Taxation Act, you actually won't see the word marijuana anywhere in the legislation. It is only referred to as cannabis.
I cannot say, I just said that for the record, I said
Got
that
it.
earlier.
It is.
Yeah. But it's a very interesting thing. The MRTA makes New York the 15th state to legalize recreational marijuana, the 16th area if you count Washington, D.C. The MRTA consolidates New York's adult use cannabis program with the state's existing medical marijuana program and the cannabinoid hemp program. The consolidated programs will be under the control of the Cannabis Control Board and the Office of Cannabis Management. The MRTA establishes a licensing and taxation system for recreational marijuana sales, and the MRTA immediately legalized recreational marijuana. So people can be smoking cannabis outside. They're not doing anything illegal. You can have up to 24 grams of concentrated cannabis. The MRTA also creates social and economic programs to encourage individuals disproportionately impacted by cannabis enforcement to participate in the cannabis industry. That was a huge aspect of the MRTA. They really want to promote social and economic equality and programs. So, that'll probably come out more in the regulations as well. The MRTA creates 3 new bodies. I mentioned the Cannabis Control Board, which is responsible for implementing and regulating the cannabis industry. We also have the Office of Cannabis Management. They're responsible for the administration of the cannabis industry. And then you're also going to have a 13-member advisory board which is going to be advisory to the Office of Cannabis Management. And that's going to include experts in several different fields, including health, social equity, cannabis, agriculture, and they're going to be from geographic and diverse areas. So not just all from New York City, they're really going to be spread out. The state expects that adult use cannabis is going to generate $350 million in tax revenue, and that it's going to create between 30 and 60,000 jobs. So this is no small industry. They have big expectations.
So when they're talking those numbers, I think that's not first year numbers. They're talking, I assume, over a certain period of time.
They haven't specified. I assume it's going to be over a period of time. I just don't know how much time they're looking at. I mean, I think these numbers are high, but the expectation that could happen in a year is crazy. So the MRTA is not intended to limit the authority of any government agency. It's not intended to allow driving under the influence of cannabis. So while you can smoke outside, you cannot smoke while driving your car. That's not allowed. It's not going to allow individuals to engage conduct that endangers others. It's not going to allow smoking cannabis in any location where smoking tobacco is prohibited. So if you can't smoke tobacco, you can't smoke cannabis. And it's not going to require any individual to engage in conduct that violates federal law, except for smoking cannabis, which is still illegal federally. So this was a kind of an interesting add-on for the MRTA. And I'm trying to move fast because this is all kind of background information. If you have any specific questions, please let me know and we can dive in deeper into one of these areas. So the MRTA creates several categories of cannabis licenses. So they're listed out here. I won't go into any details. The focus on this conversation today is on adult use retail dispensary licenses and the on-site consumption licenses. But I do want to point out that the MRTA is going to place restrictions on the type of licenses that a single entity or individual can have. All licenses expire within 2 years of issuance, and they are going to be limited. So you can't get, one person can't come in and get all of these licenses. However, one entity or one person can come in and potentially get an adult use distributor license, a cooperative license, a processor license, and a cultivator license. So one person can have all 4 of those licenses. You cannot, if you have a retail dispensary license, you can't have any of these other licenses. And even if you have an on-site consumption license, you can't have any of these other licenses.
Drew, when you say it's being restricted, do you know if it's restricted? One person can't come in, or organization can't really buy all of them up. But is it restricted also in part by geography, or that's not part of the equation?
Yeah, no, that's absolutely part of the equation. So there are, and I believe, I don't have it in this PowerPoint, but there are actually criteria that are going to be looked at for these licenses, and geography, how that license might impact the area, how is noise going to impact the area. The Cannabis Control Board is going to look at all these different criteria, and there's a whole bunch of criteria set forth in the MRTA itself, but they're also expecting additional criteria to come out in the regulations. So it's not going to be just anyone coming in. It's going to be an evaluated process and whether you meet the right criteria. There's also part of that social equity is going to be preferences for certain individuals and certain organizations to try and promote that, to try and encourage people who have been negatively impacted by cannabis enforcement to apply for these licenses. So they will have some preference when it comes to these licenses. Does that answer your question, Jeremy?
Yeah. Did you hear me? Yes, sorry.
Yes, cool. a little hard. So back to focusing just on adult use retail dispensary and on-site consumption established licenses. If the municipality chooses to not opt out, and we talked about that last month, we'll talk about it again in the next couple slides. If you don't opt out, there is a notification provision in the MRTA that requires that not less than 30 days nor more than 270 days before filing an application with the state for any adult use retail dispensary or on-site consumption establishment, the applicant must notify the municipality where the premises is located of their intent to file such an application. So this notification must be sent before the application is actually filed. Then the town will have the option to submit an opinion in favor or against the license. When the municipality expresses an opinion in favor or against the granting of the license, that opinion is going to have to be part of the record. And then the Cannabis Control Board has to respond in writing back to the town with an explanation of how such opinion was considered in the granting or denial of an application. So we've dealt a lot with like liquor licenses, where the applicant will send a notification to the municipality and the municipality can submit a letter, but that's kind of the end of it. The MRTA is very specific that the Cannabis Control Board has to include those written opinions in favor or against as part of the record and respond. So I think that's pretty interesting. It is unique to the MRTA. I haven't seen that in any other legislation that New York has. So again, this only applies if you choose to not opt out. Obviously, if you opt out, no licenses will be issued for the municipality, so you'll never receive a notification. Now, this was a question that came up last time, and it came up from Jeremy. We talked briefly about what the tax benefits are for the for a municipality. So the total sales tax that's going to come is 13%. 9% goes to the state and 4% goes to the localities. 1% to the county, 3% to the town, city, or village. So according to the American Cannabis Company, more than a quarter of retail dispensaries generate annual revenues over $1 million. So if we look at what it would mean if we had a retail dispensary generating $1 million in sales, how much money would the town of Newcastle get? So for $1 million in revenue, 90,000 would go to the state, that's that 9%. 10,000 would go to the county, that's that 1%, and 30,000 would go to the town. Again, that's that 3%. 15% of cannabis retail dispensaries report between $500,000 and $1 million in annual revenues. So if you have a business generating $500,000, again, that's $45,000 to the state, 15% to the town, and 5% to the county.
15% to the town?
15,000.
15,000, yeah, I'm sorry, 15,000. So these, again, how much money is generated by the retail dispensary is going to depend on the location and the size and the facility itself. So these numbers, you know, are just estimates. This was, again, from the American Cannabis Company.
I wonder where they pulled those numbers from, what municipalities, where they are, what cities.
This was just a national survey that they performed. So they looked at this on a national level, not from any particular state or area. Beyond that, I don't know, you know, the details of what went in to generate those numbers. And again, the county has to distribute the money no later than 30 days after receiving it from the state comptroller. And the revenue will be distributed in proportion to the sale of adult use cannabis. The retail, and it's going to be reported through a seed to sale system. So it's going to be very strictly monitored from the very beginning to when it's sold to the customer. So I think the most important thing that Newcastle needs to keep in mind is the opt-out authorization. So I mentioned it before, the MRTA gives gives towns the ability to opt out of allowing adult use dispensaries and adult use consumption sites to operate within the town's boundaries. Again, it's just these two licenses. You can't prohibit the delivery license. You can't prohibit micro businesses. Any of those other licenses that were on my previous slide cannot be excluded.
What again is a micro business through?
What?
What again is a micro business?
Yes, let me read exactly what the MRTA says. So they don't have a lot of information about micro businesses. A micro business license shall authorize the limited cultivation, processing, distribution, delivery, and dispensing of their own adult use cannabis and cannabis products. The size, scope, and eligibility criteria of a micro business shall be determined in regulation by the Cannabis Control Board. So we
So
don't
that's-
know much, but we know that a micro business can do it all on a small level.
And we can't opt out for that if we were so
And you
inclined.
cannot opt out of micro businesses. That's correct.
So that's like a farm stand?
Farm to table for cannabis?
I think about it more as like a micro brewery type situation where the facility is brewing its own and then selling it at a very small scale. Again, we won't know more until the regulations come out. And yeah, so they just kind of drop that in. You'll only see it once in the MRTA. The phrase micro business doesn't come up again. So we'll have to keep our eyes and ears open for what eligibility criteria they develop.
And that has a consumption site component to it?
Yeah, I don't believe it's consumption. You can't have on-site consumption at a micro business, but they can dispense the adult use recreational cannabis. So they can sell it, but you cannot smoke it on site. That's just adult on-site consumption facilities. So back to the opt-out authorization. The establishment of a retail dispensary and or on-site consumption operations authorizing the retail sale of adult use cannabis to consumers shall not apply to a municipality that adopts a local law prohibiting the granting of such retail dispensary license and or on-site consumption facilities within their jurisdiction. It is an and or. You can choose whether you opt out of one or both. I can tell you that I looked into some municipalities that have already opted out. We have the town of Somers, North Castle, the village of Atlantic Beach, the village of Bronxville set their public hearing, but they didn't adopt it yet. Village of Floral Park, village of Lawrence, and the village of Larchmont. Larchmont also set their public hearing. It's not officially adopted. So these municipalities all took action in May and June. Those are the only ones I could locate that have.
Eastchester, I think, also opted out.
Eastchester?
I think so.
I'll add that to my list. All right. So the right to opt out does not apply, as we said, to any cultivation or processing of cannabis within the town. Again, it's just these two licenses. You have to choose to opt out by December 31st, and the local law is subject to a permissive referendum. Municipalities cannot opt out after December 31st. However, you can, if you choose to opt out, you can always opt back in. If your municipality previously adopted a local law banning the retail sale, such local law is not valid. So the town of Newcastle has not previously banned recreational marijuana. We do have some zoning provisions, and I included in the packet the previous maps that went along with those zoning provisions, so we can talk about them afterwards. So again, the local law to opt out is subject to a permissive referendum. That means that it has to be approved by an affirmative vote of a majority of the qualified electors of the local government voting on a proposition for its approval if a petition is filed within 45 days with the town clerk. Such petition must be signed and authenticated by the qualified electors of such local government pursuant to Municipal Home Rule Law 24. So thinking about this timeline wise, what it means if you want to put this on with the general election, let's say a petition is filed within that 45 days, that means that July 19th, 2021 would be the last day the town can adopt the local law. That gives 45 days for voters to file a petition. That puts us at September 2nd, 2021. That's the last day to file a petition. And then at least 60 days must pass before the proposition can appear on the ballot. and that would put us at November 2nd, 2021. Again, that's just if you want to put it with the general election, you don't have to. You can have a special election to have to vote on the proposition. But I thought it was good to keep these dates in mind. Right? Any questions about that?
By doing it by July 19th, that would then save us money. If there was a permissive referendum, then we don't have to hold a special election and go to that expense. If we can get it done before then if there is a permissive referendum, it can be on the regular ballot in November instead of having to have a whole new special election, correct?
Absolutely, yes.
So,
Yep,
so to do that timing wise, the next board meeting after this is July 13th. So we would tonight have to adopt a resolution introducing the law and scheduling the hearing if that's what the board wished to do, to get it adopted by the 19th to get onto the special election, the November election should a referendum be submitted.
Right.
Okay.
Wait, we would have to have a public hearing on the 13th?
On the 9th,
On the 13th.
on the 13th, yes.
We would send it tonight, to the 13th.
Okay, got it.
I don't think this needs to be on the November ballot. I think that doesn't need to be there. I think this town board can make the decision, and ultimately the town decides to miss a referendum, we'll do that. But I don't think this needs to be, if I'm understanding Drew correctly, we can put this forth now for a special election vote.
No. It's subject to a permissive
I get that.
referendum.
I understand.
So if whatever we did to it, if voters in this town decided they wanted it to be on the ballot, if we do it timely, then it can be on the ballot in November, only if they got all the petitions signed and there was a permissive referendum. Otherwise, they can do it anyway later, but then the town needs to pay for a special election.
Yeah,
Which would be nice not to have to pay for that.
Right, I don't think we have to rush this through, that's my personal opinion. I think we just have to look through it, just the homework to be done, see what other communities around are going to take these same steps as we are. But that's a conversation for another day. I don't think we have to rush to have a public hearing in a week to start this process.
I think we should. I think it saves a lot of money if somebody did a permissive referendum. If they don't, it doesn't matter.
So again, I understand that, but so continue, Drew.
I was just going to say, we might have, when you hold the public hearing, you might get a clear idea of what the community wants.
Right.
And so the opposition, the town board can choose to not adopt the local law. And if you're not seeing any opposition, the chances that a permissive referendum would be filed, I think are slim. So we will be able to gauge the public.
That's a good point.
And then the resolution for tonight would just be to open the public hearing on this topic. Is that right?
Would be to
Set the public hearing for July 13th. We would have a public hearing on the 13th.
But there's not a draft position or legislation that we would be.
No, well, Drew could take and draw it up for us if we wanted to. There was no public comment when we did the local law that severely limited.
Right.
The location.
So I guess
And we haven't gotten reams of people contacting, we need to have a.
So I guess
That's
my question is,
I mean,
let's just, for the purpose of argument, would we be saying this evening that we would be making a proposal that the town would opt out?
Yes.
And that's what
The
the
public
public
hearing
comment
on.
would be reacting to
Right.
that proposal that the town would
Yes.
opt out.
It's
Not
open,
just an
yes.
open, we don't know what we're doing, but we're gonna open public comment to see what y'all think.
No, that it would be for a specific action, the specific action would be that we would be opting out.
And then, I'm sorry, can I just say this one comment? So then if we attend the public hearing and let's say that the public is, supports the opting out, but there's still a, population out there who doesn't agree with opting out, then they would have the ability to go for the permissive referendum? Is that okay,
Yes.
okay. Thank
And
you.
it's-
I just needed to understand the process.
Right, and I guess the other thing I'm just wondering is if based on the timeline for all of this, whether there'd be enough time for public comment on this topic before we to hit the deadline for the Drew just laid out? Like, is that one public comment session? How long, how much public comment did that accommodate if we did it tonight?
You would have the hearing on the 13th, so it could be one town board meeting.
One
And
session?
then we'd have to vote on that.
I mean, my
Because we're
view
not
is,
meeting again until the 27th.
my view is if we opt out, we can always opt back in.
Correct.
But if you fail to act, you can't opt out. So my thought is, why not do it? We can potentially save the town money, just like actually North Castle said specifically, they did it for that reason, so that they could have if there was a referendum, it could be on the regular ballot instead of having to spend additional money. And then we can always opt in if we felt that it was the right thing to do.
I get that point. I'm just wondering whether one session is enough.
Yeah,
so
I think to run this, my view, to run this through is to put it on, in the event that there is a referendum to somehow to protect us, but I don't think it'll ever get to that point. I don't think there's an overwhelming amount of people, because we have heard nothing from people saying, let's go, we need our cannabis, we need our marijuana, we need our dispensaries, we need to start growing.
Talking to the wrong people.
I just have more fun friends than I have. My friends are kind of boring. But no, in all sincerity, you would think we'd have much more comments, and that simply has not been the case for a while. We made it clear, even out of the gate, we'd very much consider the opting out, and I think we still are on the same page. So I don't see a rush to do this. I'd like to see what happens to neighboring municipalities and what's going on and how things evolve. And there's things that even, for example, Drew doesn't know what the heck is a micro business. I think there's a lot to learn, and I don't know where to rush through it.
So, but I think there's an opportunity to just make one decision at a time. And so what this one is, we have our inclination, and we're gonna open public comments on it. We could decide that we're not ready to close the public comments on it. We could decide on the 13th that we're not
That's
actually
true.
ready to vote on the topic, and we're going to,
Hold it over.
not worry about the deadline
Yeah,
for
for sure.
submitting, petitions to get it on the
That's
general
fair.
election ballot. Like, I don't see any reason not to open the topic to the.
That's
I
fair.
agree.
That's
I
fair.
agree.
That's fair. And I appreciate it.
So Nick tells me that they have the local law ready. So if you want to forward it to us, we'll take and print it off, and we'll have it further for them to be able to set the public hearing for the 13th, and we'll open the hearing and see what kind of input we get from the public.
Yeah, and just take it one step at a time.
So we'll send it to you when we're done with
It
this.
seems like it
presentation.
would be
Just
so
gotta send it.
premature to opt into this at this point, when there's so much in the legislation that hasn't been defined, that it would be such a mistake to not opt out. So I kind of see, unless we get significant input to the contrary, why wouldn't we do it?
Yeah.
If it makes sense and we can potentially save the town money.
I agree. I do look forward though to the opportunity to hear what people have to say about it.
Me too.
So, as I said, I kind of wonder if one session is sufficient for that, or if we want depending on how the person
When we limited the sites where, a vape shop could be established within a town, we got, it was,
This is a larger scale
Was it
change with the
Yeah.
state though. I think it's a different,
Yeah.
it's the same sort of thing.
Yeah.
If people were really interested in vape shop or
Shopping for vape.
shopping for vape or having that kind of accommodation
Right.
within town.
yeah, but at that time, there wasn't state law legalizing marijuana.
True.
What was on the table was a different thing.
That's also, $30 grand is not to, discount 30 grand is 30 grand that we didn't have.
Oh,
You're assuming.
we would have to spend much
I know,
more
but
money.
I'm just saying, it's just interesting to know what the financials look like too.
So I appreciate you, Lori, making that clear. I have no issue with opening the public hearing, but I have no rush to close it.
Okay, that's fine.
All right, so that'll be July.
Did last time I talked about this presentation, the local law was in the agenda packet, so the idea was made public before. We just didn't have a clear understanding of the timeline, and I can't believe it's already July. I don't know where the timeline, everyone. Great, so once we do that, we'll get a better idea of how the community is feeling, and as we discussed, you can always opt back in. And if you do choose to opt back in, one of the things to keep in mind are reasonable local restrictions that you can impose on retail dispensaries and on-site consumption sites. So the MRTA gives municipalities the ability to to adopt local laws establishing reasonable time, place, and manner restrictions. Municipalities can incorporate these local controls within the zoning code. Time, place, and manner restrictions aren't defined anywhere, but you see them applied a lot with like wireless structures. You have to have reasonable time, place, and manner. You see them a lot with adult use establishments. Reasonable time, place, and manner comes up a lot when you talk about those in the context of constitutional law. So the same idea is going to be applied for cannabis, retail dispensaries, and on-site consumption facilities. The key is that you cannot adopt a local law that makes it unreasonably impracticable for these facilities to be established. And that unreasonably impracticable is going to be determined by the Cannabis Control Board. And we don't know what that procedure is going to look like. Does someone challenge it straight to the CCB, or does the CCB get involved if there's an Article 78? We don't know that yet. We anticipate that it'll become more clear in the regulations. But again, it's this unreasonable time, place, and manner, and you can't have that anything unreasonably impracticable. So that means having them, zoning them into a place that's maybe on the edge of town, or zoning them in a place that will actually never become available, or zoning them in such a way that there's actually no reasonable locations for them to be established. And we had this conversation more when we talked about retail dispensaries and vape shops. So it's not a new idea. It's not a new conversation, but now it's, set forth in the MRTA. So we need to kind of keep it in mind and pay attention to what's going to be a reasonable time, place, and manner. So that brings me to my next slide about what are some examples of reasonable restrictions. So he said that municipalities can regulate retail dispensaries or on-site consumption establishments by specifying a particular distance from residentially zoned areas and facilities in which families and children congregate. You might want to consider restrictions on the hours of operation. You might want to use zoning to prohibit such facilities from operating within a certain distance from each other. I will note that the MRTA already includes a separation requirement of 500 feet from school grounds and 200 feet from houses of worship. We believe that municipalities have the right to increase those distances. So other things to consider are you going to require site plan approval, special permit approval? You want to focus on the location of these uses. Again, the distance from schools and houses of worship, although it's already in the MRTA, would you want to expand those distances? Restrict hours of operation, focus on lighting and security requirements, nuisance provisions and odor controls and other performance standards. These are all areas that you can regulate that would be acceptable time, place, and manner. So I just want to highlight a few municipalities that I went to look at. I know last time we discussed this topic, Jeremy, one of the questions you brought up is what are other municipalities doing in areas where this has been legal? So I really focused on Massachusetts. Massachusetts recreational cannabis became legal December 2016, and sales began in 2018. The Massachusetts law has very similar language to what the MRTA says. So I just want to read, they use the language about not having, that you can't adopt regulations that are unreasonably impracticable. And in Massachusetts, unreasonably impracticable is defined as the measures necessary to comply with the regulations, ordinances, or bylaws adopted pursuant to this chapter, subject licenses to unreasonable risk or require such a high investment of risk, money, time, or any other resource to assist that a reasonable, prudent business person would not operate a marijuana establishment. So we don't have that clear definition in the MRTA, but I think it's fair to look at what Massachusetts has as guidance. So in the town of Linfield, you see that they focused on, they went in two directions. They focused on location and they focused on signage. So for location, they said that the marijuana dispensary can only be located in the commercial district. It has to be approved by a special permit. And then it sets forth some extra requirements. Again, that distance requirement, you see the 1,000 yards of any school, church, licensed childcare facility, playground, place of worship, or any other registered marijuana dispensary. No registered marijuana dispensary can locate within the same premises of a doctor's office or offices of any other professional practitioner. And any and all cultivation, production, storage, display, sales, or other distribution of marijuana shall be located so as to occur only within the restricted area of a registered marijuana dispensary and shall not be visible from the exterior of the business. Then they focus on signage and they say that any and all signs related to the registered marijuana dispensary must be located on the same building in which the registered marijuana dispensary is located and must comply with all sign regulations of the town of Lynnfield. No sign, advertisement, display, or other promotional material which utilizes graphics related to the marijuana or marijuana paraphernalia or figures or symbols related to marijuana shall be visible to the public from any public way, including but not limited to sidewalks, pedestrian ways, or walkways or highways. I think it's interesting that the MRTA has nothing about signage in it at this time. We believe that the regulations are going to expand on that. So we expect some details about, what signs you can post, where you can post to be in the regulations. But again, if that doesn't happen and Newcastle chooses to opt in, signage might be an area that you consider regulating. Again, keeping in mind that we have to also be content neutral, so we'll have to navigate those waters as well. So I won't go into the same details for the town of Marshfield, but again, it's in your packet. You can look at what they did. Similar idea, but again, these are regulations that have been deemed acceptable and they are not unreasonably impracticable. I also put in the city of Denver. Denver legalized recreational marijuana December 10th, 2012. One of the things Denver does that's very interesting, and I haven't seen it in many other places, is they have an interesting nuisance provision to help regulate cannabis and some other uses as well. This applies to a bunch of different things. I'm obviously only focusing on its application to cannabis. So they define nuisance as the doing of or the failure to do something that allows or permits air contaminants to escape into the open air that tend to be detrimental to the health, comfort, safety, or welfare of the public, or that causes or tends to cause injury or substantial annoyance or inconvenience to persons exposed thereto, or causes or tends to cause damage to property. So they said that anything to do with cannabis anything to do with the growing marijuana, processing, manufacturing, requires an odor control plan. So you have to submit an odor control plan to the manager of the Department of Public Health. They approve it. The plan is going to outline how you're going to prevent nuisance odors, how you're going to control nuisance odors. And then if someone, claims that you have an odor problem, an affirmative defense is that you're complying with your odor control plan. I haven't seen odor control plans elsewhere, but I think it's a very interesting idea. I know if you've ever been to Denver, the outside of Denver, it's in a valley. The smell kind of lingers a little bit. So I don't know how well their odor control plans are working, but it is, it's an interesting idea and something that might be worth considering.
I was thinking the same thing, Drew, based on my last trip to Denver. It's not working very well.
Yeah. As a little bit of odor.
That's true.
I'm sorry, I'm talking so fast. I'm trying to move quickly, but if there's anything you want me to go back, please let me know. Personal cultivation is in the MRTA. I think it's so interesting, and there's not a lot of meat to it in the MRTA, and we're really going to have to wait for the regulations to come out so we know how municipalities are best to regulate personal cultivation. Right now, we don't know much. We know that you can't prohibit the personal cultivation of cannabis. That's not allowed. People are going to have a right to grow pot plants if they want to. You can't have more than 6 mature and 6 immature cannabis plants on your property. The difference between mature and immature is budding. Mature plants have buds, immature plants don't have buds. I don't know who's monitoring when an immature plant becomes a mature plant. They don't talk about that. They just limit how many you can have. A personal individual can have 3 mature and 3 immature. The 6 is the maximum for the property. It is clear that the cultivation of cannabis is only permitted on a private residence. You cannot grow pot in a community garden. That's not going to be allowed. But it's unclear on how this is going. It's unclear how this is going to apply to apartment buildings, or to even 2-family residences. So, you and your roommate, if there's 2 of you, you can have 6. But if there's 3 of you, you can still only have 6 on your property. 6 maximum. The only rule that's in the MRTA is that you have to take reasonable steps designed to ensure that such cannabis is in a secured place, not accessible to any person under the age of 21. What I take that to mean is that you can't just grow cannabis in your backyard. You're going to need some sort of fence. It'll probably have to have a lock on it. Maybe you want to grow it in a secured greenhouse outside or in your home, but it's not going to be allowed just in your backyard where anyone under the age of 21 can access it. And so the regulations are going to expand on that, I hope, because the MRTA doesn't give you much. And we do know while municipalities can't ban it, you can adopt reasonable regulations to regulate personal cultivation. Maybe that means establishing certain setback requirements. Maybe that means establishing a registration program if you're allowed to do that. It'll be more clear about how best to handle this when we know what the regulations are going to provide. And I do want to make it clear that you cannot, while you can go out and you can smoke cannabis right now, you cannot go out and start growing a cannabis plant. The personal cultivation of cannabis is not going to be legal until 18 months following the first authorized retail sale. So there's a lot of steps before we get to that point. First, they still have to appoint the Cannabis Control Board and the Office of Cannabis Management. Then they have to develop the regulations. Then they have to legalize the recreational sales and just establish their licensing program. And then after that, a couple months later, you can buy your personal cultivation cannabis plant. So there's no rush to get these regulations on paper. And we think it's best just to sit back and see what the Cannabis Control Board's going to do. But it'll be interesting. So the other issue that we talked about last month was the smoking of cannabis. So it is clear that adults 21 and older can generally smoke cannabis anywhere it is legally, you're legally allowed to smoke tobacco. The converse is true. If you can't smoke tobacco, you can't smoke cannabis. In addition, smoking cannabis is prohibited in schools, in workplaces, and in cars. While you can drive around with cannabis secured in your trunk or secured in your back seat, you cannot drive around smoking cannabis like you can smoke a cigarette. That is prohibited. Municipalities can adopt regulations to allow smoking cannabis in locations where smoking tobacco is prohibited. That's in Section 2 of the MRTA. I think it's a very interesting way they phrase that, but something to keep in mind. And the town of Newcastle already prohibits smoking in parks. Smoking includes tobacco and cannabis. Now, if you want to go beyond that, you're allowed to do so under the public health law. So the public health.
Drew, what about in lieu of smoking? Because everyone gets caught up with smoking. You can consume cannabis in a heck of a bunch of different ways.
Right.
So is there anything to prevent the use of an edible, for example, at the park? Or is it just smoking?
It's just smoking. The definition of smoking doesn't really address any aspect, it includes vaping, but there's no part of that definition that includes consumption. And I don't know how that'd be tricky to regulate. I know that
that's not the issue, because enforcement is too hard in general. You catch people smoking in parks and vaping. Realistically, it's not so easy, but you don't want people
And I do know that some of the money that's going to be generated from this industry is being set aside for training of law enforcement and training them on how to identify if people are stoned in their vehicle. You know, what are the, how can you do that? I think they're also training dogs, I heard. Don't quote me on that. I don't know if that was someone trying to trick me, but I heard dogs to train to sniff being, you know, if someo's high. Because again, you know, if you're consuming it.
It's only miniature dachshunds though, that's the.
So,
You know, I know everyone might be thinking, oh, it definitely has an odor, but again, if you're consuming an edible, that might not have any odor, and so it'll be very difficult to tell if you're stoned or if someone's just tired. You know,
but Drew, is there a regulation of where someone can be high?
No.
Right, so it's about like interfering with someone else's enjoyment of a space.
Well, we disorderly
Right,
conduct.
there's regulation of smoking, because smoking in a park may interfere with other people's enjoyment of the park.
Mhm.
But, you know, the use of an edible product doesn't necessarily interfere with someone's enjoyment of the park. If you're legally allowed to be under the influence of marijuana in the park, how you got there is,
Yeah, that's why that's.
maybe there's
But
flexibility
is it
around
going
that.
to be allowed to?
Right, I agree with that. If you're acting disorderly, there are provisions that, you know, you can get in trouble for if you're doing things that are inappropriate. That's not just a cannabis thing, that's disorderly conduct
Right.
or whatever you might be doing, that could be in violation of a different law.
Right.
And again, you can't be high and driving your car. That's not okay. But you could be stoned in the park, and if you're not bothering anybody, then I don't know what you'd get in trouble for.
Got it.
One of the things to keep in mind is that you cannot, while the law gives the public health law gives municipalities the right to ban smoking in locations outside the public health law, you cannot ban smoking on sidewalks. That's not allowed, but you could ban smoking in, you know, around town hall or in public parking areas. So there are, you know, things you can consider if you'd like to adopt additional no smoking provisions. And I think that was it.
Cool.
Wow, Drew.
You are an expert.
So Drew, so it's my understanding that most municipalities in northern Westchester seem to be on track to opt out of this, at least for now, just because there's so much still unknown about the regulations. Do you know any that are opting in?
So that's harder to track because you don't have to do anything. If you don't have to do anything formal to opt in. If you don't discuss it, if you don't take any action, you automatically are in. And that means that the Cannabis Control Board can issue licenses for retail dispensaries and on-site consumption facilities located in that jurisdiction. So, you know, if you're not doing anything, you're going to be in.
Okay.
So as of now, the default is most are in.
Exactly, most are in. And it seems like a lot are opting out, but that's because the news stories focus on who has been discussing opting out. You know, nobody cares about the people who are just going to who are going to opt in.
Didn't Ivy kind of have like an off-the-record survey of who was thinking about opting in?
She made a reference.
Yeah, I've
to it,
spoken to a lot of municipalities and they all seem to be opting out.
Say that she said Austin was thinking about opting in.
All right,
Yeah.
thank you,
She
Drew.
listed a couple that
She did.
were adjacent or near us. that were
Right, because
considering it.
yes, because we were commenting about the fact that our residents would have just a short drive away to be able to take
Yeah.
in patronizing.
I thought it was reading maybe Peekskill was thinking about opting in.
But yeah, because the other issue is if nobody near us is opting in, then we would get more traffic for people who want to purchase, which can cause other issues. Whereas if everybody's opting in, then you're not gonna necessarily get people coming to one town versus another.
Well, and keep in mind, delivery licenses, you can't be stopped. So people can have a delivery license, you can get cannabis delivered to your home.
That's gonna be.
Yeah.
Maybe that's gonna be right.
And Connecticut just legalized it, but I don't know what their rules are.
All right, thank you, Drew.
You're very welcome. If anyone has follow-up questions, just shoot me an email. Thank you for your patience and listening to my little presentation.
So Drew, good job. If you could just send a copy of the local law to Christina.
Absolutely. Christina, it's
Great.
coming your way.
Okay,
So do we have to set a public hearing?
Yep, we'll set it up here with our resolutions.
All right, Joe.
All right, back on track. Can we go back for 1 second to the AMI things while we're still here? Because that was not on our agenda for tonight, and I really would like 80% studied as well. I think there are plenty of buildings that have 10% requirement with 80% AMI, so I really like that studied as well.
That's the
I mentioned it to Sabrina.
Listen, I think if Sabrina says otherwise, and this seems to be the consistent thing to do in terms of the E30, I don't see a reason.
3060.
Well, it's
3060. 3060, I apologize.
But it's not. Sabrina said that, I just did research, there are plenty that are 80%, 120%. I think if we're gonna make an actual evaluation rather than say, okay, we're only having 5-story buildings, because that's the only way it's gonna be affordable, because we're gonna use a 30% requirement. If that's what you wanna say publicly, then that's fine, but I think to have it studied to get a fulsome information is completely appropriate.
Okay, again, I think if Sabrina seems to think that that's appropriate, then I think we should consider it, but right now it doesn't.
She just texted me that it's fine.
So she just spoke to us before, so if she wants to share that with us, we can discuss it, we don't have to do that tonight anyway, so.
She said it's the board has to decide that, and we are going back, she's going back to our consultant, and we need the appropriate information if we're gonna study it. You just said that last week, we need to gather all the information. So let's do that. Please don't fight every single thing that ever comes out of my mouth until the end of the year. Like, I think it's really important to understand this information.
I think you're absolutely correct, I think they're doing a good job in terms of Sabrina making sure that she's following up and pursuing it. So I think we should continue on the trajectory that we are, and if Sabrina shares with us that we really should do it, and it's, like she said otherwise just before moments ago, then we'll reconsider.
Okay, but you're also not a dictator here, so there are other people in this room who get to decide whether appropriately analyzing information is something we should have. So if everyone else says appropriately getting information is not what we should be doing, then that's fine.
I don't think anyone would say that. I don't think.
Well, that's what
Wasn't on
you
your
are saying.
agenda.
Excuse me.
And it
It
wasn't
wasn't
on the agenda.
agenda.
So to spring it on us now to make a decision is completely inappropriate, first of all. Sabrina did. And if I'm asking that, I think we should get one more piece of information. I don't know why that has to be a battle.
Okay, so I don't think Sabrina sharing information with us is not an issue of the agenda, because we're not voting on anything right now.
We're going back to get it studied.
So Sabrina sharing that information is not mandating a vote. You wanna have more, so we'll talk to Christina, pardon me, Christina. We'll talk about it more with Christina. So we'll discuss it, so I'm not opposed to discussing it with Sabrina if she's doing something to pursue it. There's so many different things, no matter, there are certain people who are named nameless who will just have you study and study and study and study for the purpose of studying and delaying, not actually being
It's the same study,
So I
it's
would
taking
share with you-
30%, 60%, 80%.
So if Sabrina thinks it's something to do, I don't object to it at all. I rely on other professionals and we'll speak to her. I'd like to hear what she has to say.
The thing that I am objecting to is the texting of what should be on our agenda and our decisions. Like if we're gonna consider a proposal, then we need Sabrina back in the meeting to consider a proposal.
Yeah, that's fair.
Like one board member texting with a town staff member and driving a decision is not.
I'm not driving a decision, I asked her if it was appropriate to study that. I asked a question to get
Okay, so
information.
now, but now
That's why I'm
you're-
bringing it up here.
Great. But we don't have access to that. So can we have Sabrina join us?
I don't know, I'm asking if she's available.
Okay.
Thanks, Jill.
Next on the agenda?
Yeah, so the next thing that we've got on our agenda is authorization for pavement purchases. So, from Bart here somewhere, here we go. So, Bart is asking authorization to cut a purchase order to Montesano Brothers, who is our paving contractor, in the amount of $1,223,870.78 for road paving for 2021. Because of the size of the purchase, we always bring it to the town board for approval. So, Montesano Brothers has renewed their bid contract for the paving season. It was approved by the town board on May 25th of this year. We were just trying to be proactive in scheduling the road paving, which is going to be the end of July, beginning of August. This heat, although it's tremendously oppressive for everybody, it's fabulous paving weather.
Oh, great.
Because
fascinating.
you know, it's one of those things that you do in this lousy weather.
And they really respect people who do that.
Because, yeah, they really have to, like, anyway, so this is gonna be on the agenda for your approval tonight, just as a pro forma. The next item we have is payment of claims. Adoption of minutes from the 15th and the 23rd. Lisa, we held the 15th.
Yeah, you know what, they're not, with all due respect to whoever drafted them, they're not even in complete sentences. There's so many typos, I need to rewrite it completely, and I didn't have the time to do it, but I will definitely do that.
I emailed Lauren a comment back on last week's
Okay.
minutes.
So,
Request for an edit.
We're not doing that today.
Lauren, I will rewrite them and get them to you
well, it's,
this week.
so Lauren goes by the transcript, by what was actually said. So although it may seem like incomplete sentences, because when we speak, that's what happens, but they're the clerk's minutes, so as long as they're accurate to the actual record,
And they're not verbatim.
they're
No, they're not verbatim, I know, but they're not even, I
Yeah, I
couldn't
was
even
just-
understand some of it.
Comparing the sentence to, like, I actually went back and watched the video and it's like, it's pretty
Okay, all
far
right,
off,
well,
so-
I'm happy to,
table.
yeah.
Okay.
No, that's fine. But just so everybody's clear.
Yeah, no, I get that it's not verbatim, it was,
No, it's,
the edit in particular was.
yeah. The next is an authorization to designate the acceptance of the high bids for vehicles and equipment on the Auctions International website. So we've got things that are going to be going out to auction terms. And so this allows Bart to be able to accept the high bids without going back to the for every. Next is authorization to purchase materials and engineering services for data transmission. This is part of the Millwood Water Treatment Plant. Regular purchases, and last but not least, we've got an authorization to approve a noise variance for 415 Sauls. That was a late addition that came in to the agenda. We've got a gentleman who was about to do with a cancer fundraiser at his home, and he wants to do a waiver of the noise ordinance, I think until 10 o'clock. We have it in our resolutions. The only thing I was gonna ask of the board is on the actual resolution, if we could modify it slightly. The gentleman told me that he is expecting about 125 people, and so I would like the police chief to be able to just review his parking and confirm the chief may determine that some police presence is necessary to just keep everything orderly and roads clear for any sort of first responders who may need to gain access to the area.
Okay, so that's not, our approval is not dependent on that review, just that it will happen, is that right?
We could do a contingent to, or you can kick it over until the chief has an opportunity to look at it on the 13th.
What's the event?
Not until September.
Okay, that's it.
So
I think I had
if you'd like to do that,
Yeah.
yeah, so he was just being really proactive, and I very much appreciate those efforts.
We don't feel like a lot of neighbors in
I don't, he told me that he was planning on sending out a letter to all of his neighbors and to, Sabrina's here.
She was.
He was sending out letters to all of his neighbors, inviting them, and, he had a parking plan for Breckenridge Road, but 125 cars is an awful lot of cars. You have one person who doesn't quite understand where to park, and somebody's driveway's blocked. We don't need to do that, we can make sure that it's
Yeah.
organized.
Okay, so we could probably wait.
Yeah, we could wait, right, Jill?
Yeah, I'll let him know. I told him if there was any issues at all, that I would pull it for the next week, so he already has questions.
Okay, thanks, Jill.
Speaking of noise ordinances, do we have any updates on what that person wrote in about with the Action Lab Center?
Yeah,
Yes, so we have a, Tom Toll has a meeting with them, tomorrow, to go over with them the information to review the special use permit. The special use permit evidently is, issued to the owner and it runs with the property, and there are things that are on the website that are not consistent with the permit and need to be addressed. We will be addressing.
so Sabrina's got a
Sabrina.
question about 60-30, 80-30 in terms of the AMI. Certainly Lisa can ask what she wants, but my I guess first question is, can you explain why you believe that the numbers you have at 60-30 is the appropriate numbers to pursue?
Okay, so just to kind of, let's step back and let me talk about what it means to do, for example, 10%, right? When a developer is developing affordable housing, they are spending the same amount in constructing a market rate unit as they are for an affordable unit, right? Sometimes if it's a large enough development, they'll change the type of countertops, that type of thing. Our code doesn't let them make units smaller if they're affordable. We have certain minimum sizes. So there's a cost where the developer is not getting, let's say they charge $100 for a market rate unit. 30% of 100 is $70. So they can only charge up to $70 for an affordable unit. That $30 gap, right, is what the developer is giving up because of the regulation and I say giving up loosely because they'll make it other ways. The question is, right, with all of those other things that they need to provide, the parking, the stormwater, if we are creating the commercial first floor, if we are creating a situation where economically, if they're going to do 7 units, if one of them has to be affordable, can it make it? Now, we have regulations, that define affordability by AMI, right? 30% AMI is the conifer building. I think they're at 30 and 50% AMI. I have been told that, if a developer is going to take advantage of state financing, that we shouldn't regulate 60 or 80% AMI, that we should regulate 30 and then start to allow the 60 and the 80% AMI to get the diversity of income in the building. But the question is really what works at 3 stories with a commercial first floor? Right? Does a 30%, which is the lowest of the low, work? If 30% doesn't work, does 60% work? We can study, does 80% work? It's just adjusting that component of the equation, right? And so when Kimley Horn's consultant came back and the town board approved 2 iterations, my gut was to use the 30%, which is typically the lowest, right? And the median, which is the 60%. The county doesn't typically give credit, like when we were under the housing, when we needed to provide the housing units and the housing monitor was looking at the settlement agreement. They did not include the 60 and the 80s as part of that equation. They only counted low to moderate income, which was under 50, AMI. So my thought was to prove out, does 30% work? Because that's the AMI that we would quote unquote get the most credit for as a community. If you want to do 30 or 60 or 80 or 120, that's your purview, right? And that's something, you know, I would say 120 doesn't meet our affordability law, right? So I was looking at the two most frequent categories of affordability.
Sabrina, what is the AMI for workforce?
I think the AMI for workforce is closer to 120.
I mean, if the point of the form-based code, when it was initially looked at, was one vehicle to provide different types of housing stock, I think to just limit it to 30 and 60% right now is not getting an entire piece of the puzzle. I think is it gonna be like an hour extra work for them to analyze it at 80% and even 120? And I think it's something we should have more information, not less, when we're trying to analyze a development plan for the town.
So it is possible to look at 30, 60, 80, and 120. Absolutely. The board approved a change order that included 2 portfolios, if you will. If you want to expand that to include 4 portfolios when it comes to affordability, it's in your purview. I'd want to go back to Kimley Horn and ask, is this, breaking the bank, or is it an hour worth of work? I'm not sure.
So I'd also like to know, before you make a decision, again, what is sort of the practice, or what is the more common practice, if you will, in terms of AMI? And it may be across the board. We just talked about Carnival, which is at certain levels. So we can study we have the ability to study all sorts of different things, but the question is, why study certain things that aren't worth pursuing, or are not normally accepted, or are not typical? So that is part of my question. Can we reach our goals of what we're doing now? I think we can. And at what point do we say, okay, we're going to reach our goals, we don't need to continue studying?
I mean, I have friends who are doing it at developments at 120%. So I think that's common also. So I'd like to get more information.
So Sabrina, if you could sort of get that question in terms of, similar sized municipalities and similar sized potential buildings, what are you seeing?
Is that something that the county would have that could share with us? Like what are other towns in Westchester doing as far as AMIs going for affordable housing?
Typically, they're the 30 and the 60.
60.
Okay.
But it's not just affordable. We also want attainable housing, which can be workforce housing, which can be senior housing. So to not look at that in a development plan that's being looked at for all of downtown is a real miss. To not get a huge piece of information.
If I may, and this may help, what we're trying to garner here, what is the minimum threshold? If it's not, if a 3-story building cannot accommodate a 30, but it can accommodate a 60, then it will accommodate an 80 and a 120. Then that comes down to a policy decision, a legislative decision to create a code language that allows a certain percentage of each of the AMIs to exist in a building, right?
But buildings can be shorter with the higher percentage of AMI, can be lower. So to not have that piece of information, you're basically saying we're only looking at tall buildings.
No, she just said 3-story. I'm sorry, Sabrina, I don't want to put words in your mouth. Can you just repeat what you said?
The town board has limited the analysis to a 3-story building and a 4-story building.
Right.
That's it. And so it's a matter of when we start talking about implementing a diversity of housing, both from a type and an economic indicator. Right now, we have a blanket 10%. If you were to develop in the hamlet with the existing height, you would not reach the number of units on most of the smaller properties in the study area to create an affordable unit. And if the goal here is to create a unit, a workforce unit at 120% of AMI, then it gives you the information you need to require that.
But you're saying then that the 60% will answer that question.
I'm hopeful, yes.
But you don't know.
So we'll find out then. We'll find that out.
When I first started this, I wanted a 30, a 60, and an 80. Okay, where is our bottom threshold here? The town board limited to 2. If you are telling me you want to understand the flexibility, what it would take to do 2 more and do 4, one at 120, one at 80, one at 60, and one at 30, to understand your bottom line threshold, your minimum, I'm happy to go back to the consultant team and ask them that.
Because part of it is also, we talked last week about putting a 10% affordability requirement in current zoning. So wouldn't we want to understand what it would be like in current 2 stories or 3? That's why I think we need that 80% at a minimum.
Yeah, I think that sounds good in theory. We've seen, in terms of the history of this town, things haven't happened for a reason because of the restrictions that are here. So I'm comfortable where we are now, but certainly, if I'm understanding you correctly, and you speak to Kinley Horn, if 60% will work, then 30% will work. Then that's the answer.
If 60% will work, then 80 and 120 will work.
Right.
But 30 will not. And we know, for example, that in both instances of affordability, in the cupola building and in the conifer building, the 30% was required.
Sabrina, I really want to understand 80%.
Oh, so what I'm
seriously,
going to
it's like
say is I'm
changing
looking to the town board right now to give me direction. So Lisa, I know you want to do 80%. Does the rest of the board want to do 80%? Is it in addition to or a replacement of? Because
I feel like it's changing one number in Excel spreadsheet. I'm not going to be that much work.
Listen, I am not going to presume that it's not that much work or that it is a whole host of work. Okay. I'm not the one doing the analysis. The consultant team has a market economics specialist who's doing this analysis. All right. I meet with them on a weekly basis. I will have a meeting with them tomorrow to discuss this very subject. The question is the town board authorizing me to add 80% to the discussion, or 120%, or both? Or do you want to replace the 60 and make it 80?
Speaking solely for myself, everyone has right to speak. I'm not asking you to replace anything. I'm asking you to continue with what you're doing. Should you want to make that audit your inquiry about what that means, that's certainly your prerogative, and if the town board, other people want you to do it, you should ask. I have no objection to that, but I'm certainly not asking you to change from 60 to 80 or even 120, whatever the numbers are ultimately. We've been dealing with this for a while and addressing it, and it seems to be that this is appropriate. And especially if, again, you're saying that 60 works, so does 80, so does 120. So that all being said, my position is I'm not authorizing it on this one person.
So Sabrina, one of the things that we had talked about in an earlier meeting was the possibility of having the 10% affordable requirement, and then in some circumstances adding an additional workforce requirement.
Yeah.
So the example for that, it seems, that's another question altogether, right? Which is, right, that then you're looking at perhaps like 30 and 120 together.
Yes.
Which we also haven't asked for.
Right. Well, let's just let me also kind of talk about this a little bit. We have the county's blanket percentage of affordability right now that we're talking about. The county's blanket requirement doesn't address a small development. It doesn't say if you're going to put 5 units in or 4 units, right? Which is very feasible in a 3-story building with a commercial first floor to have 4 units. It doesn't say you have to have 1 unit at 80%. It doesn't say to have 1 unit at 120%, right? It says all developments of a certain size have to have 10% or 1 unit. Right. And so my examination of this is much more granular in that, when I speak to a developer who comes into my office for permits and we're talking about how many units they want to develop, they go before the planning board and we're talking about all of this. The question comes to, this is not a conifer whose main development type is affordable housing. Right? These are our local developers who are developing in the community. When we start talking about affordable units, it's how many do you think could you do 2 units? Can you do 2 units at 30% or 120%? Like there's no flexibility right now in the codes to talk about that. And so the analysis that Rest Group is doing through the form-based code will be super informative on helping us create a better affordability requirement that meets the character of the community. Because right now it doesn't. Because if you look at all of the affordable developments that exist in our community today, they are just shy of 30 units.
All right, so.
And so this analysis is important. The question, and I am happy to have the conversation with the consultant team to ask, what is an additional 80 and 120 analysis here to understand it? And I can come back to you.
Yeah, I don't see any downside in asking the question of what it takes, because if Lisa's right and it's literally a switch in the number and an Excel spreadsheet, I mean, Excel spreadsheets can get quite sophisticated, then what is that going to cost? $3? Like, give me a break. Like, if it's not going to require time and money, then I think that it's worth asking.
Right. Well, let's put it this way. I don't know that it won't require time and money, but how much is that time and money? Right.
I don't object you to asking the question, but I don't know authorize to make the change at this point without knowing when Andy knows question to answer. So. Again, I stand by what I said, but please, by all means, ask that question, get the answer.
Yeah, and I'm happy to do so. I'm happy to do so.
Because I think part of the analysis is seeing also not just how big buildings can be, but how small they can be. So if anyone's going to actually make an educated decision about a form-based code, we need that information.
Yeah, I mean, the thing that I'm concerned about, I think, is that it provides a format to slide to something that's not actually really affordable anymore.
Well, we don't know that though.
That we'd be changing our definition of affordable for the town, something that's not actually targeting the underserved population that we need to target.
Right.
No, I disagree, because it's also supposed to cover workforce and senior housing. That was the point of the comprehensive plan. It wasn't just affordable conifer housing. It was a diverse, offering
diversity of housing type and diversity of
a diverse offering of different types of housing, not just conifer type buildings. It was workforce, it was senior housing, people who want to, leave their large homes and empty nesters. That's what we need to understand, not just how big. We know what a conifer building looks like, but I'd like to see how small they can be for it to make sense. And we can't do that without analysis.
So let me just briefly respond to that. First of all, no one's looking to build conifer buildings. No one's looking to build an entire affordable 30-unit affordable housing on
It's not what Bill Spade said last week.
No, it's absolutely not true. I don't think anything we've heard from anyone who's come to town in our group of the people who own property in town, they want to commit all of their property to affordable units. So that's not a fair analysis. That's number one. Number two, it becomes a point of opinion, because we'll certainly have different views, the objective is not to do the minimum either. You know, some
Right, but
people.
we need to understand it.
So hold on, what I'm saying is, even if 3 might work, that doesn't mean that 4 is not okay. While you may oppose 4, someone may say, fine, 3 may work, but I still want 4 anyway. So it's not just what will work as a minimum to get by and slide by, it's a bigger picture than that, but it shouldn't be couched as either a 30-unit conifer or nothing else.
No, I was
Because it's
using
not.
both ends of the spectrum. I was using the 30% and the 80 or 100% to say, we're not making that decision now. We can't make a decision without facts. And if you're not gonna allow us to get those facts, then your decision is incomplete. And based on incomplete facts. So-
Right now, the definition of affordable housing does not go up to 80 and 120% AMI.
Yeah, that's kind of what I was getting at, Sabrina, because this analysis is what is our definition of that 10% requirement? Is that right?
Well, the 10% hasn't changed. The 10% is in the code. What counts as an affordable unit right now is 60 and 30, and anything less than 30.
So if our code has a 10% affordable requirement, then the next question is, what do we call affordable?
Hang on, let me get my code.
Okay,
Let me read it to you all. Hold on.
okay.
Well, but to your point, Lori, is affordable supposed to only get at affordable housing monitor affordable, or is it supposed to be attainable also? There's a difference, and I think the comprehensive plan wanted to look at all of that, not just affordable housing. It wanted to look at workforce housing and attainable housing for seniors. So that's why we need the analysis.
So the alternative could be to let them go higher, the 4 stories you don't want, and instead of having a 10%, if you really want that, let's make it 20%.
But we're not making that decision now. We need the facts.
So the
You know
more,
what you're doing.
but
You're a
the
smart person.
the more.
I would get all the information.
The more units you can have, the more they could be affordable workforce. That's the practical reality. So whether it's 80% or 30% or 60%, if it's another 4, that's just more opportunity to allow.
But people don't want 5-floor buildings, and people don't want an entire town of conifers. So
None is an
that's
option.
why we need the information.
None is an option.
Yes, it is.
It's not. That's not what it's for.
So it is an option, and that's all we're studying right now. We need to study that 80%. And I don't know why it should be such an issue that we've been having this discussion. It's one extra data point.
So again, I think we're spinning our wheels here. She's gonna speak to them and find out what it is that it takes to get the issue. And then we'll have to decide if that's what we're looking for as a town board. So I think we're spinning wheels. I think we should move forward, and she has a task to do, and she'll do it.
Jill, did you have a comment?
No.
Okay.
I'm thumbing through right now. The question is, listen, I want to have the best analysis possible. Okay. We have a consultant that provided a change order that you approved that had 2 analyses regarding the affordability, 2 models, right? What I hear is that we want to maintain those 2, but we want to understand what an additional 2 would cost, right? And whether or not we're going to learn anything that we don't know. And is it something that's as easy as replacing a number in an Excel spreadsheet? That's the question that I'm going to ask them, right?
That's fine.
Yeah,
Great, I think we're all in agreement, right?
yeah.
All right, so I think we can move forward. I appreciate it, Sabrina. Thank you very much.
Thank you, Sabrina.
Sure, but I do want to, and I will look into this. I will find the definition of affordability that's in our code today, because that is the measurement within which we measure affordability. It's not 120% AMI.
Okay, that's really helpful. Thank you so much, Sabrina. And thank you for rejoining the meeting, Sabrina. I appreciate it.
No problem. Have a good
Thanks,
one.
Sabrina.
Bye-bye.
Bye.
Bye.
Okay, so we're actually ready for our resolution.
I move to approve the payment of claims in the amount of $319,211.25 listed on the summary pre-check writing report and detailed voucher detail report, both dated June 25th, 2022, June 25th, 2021. Checks will be issued and mailed to each claimant listed on Wednesday, June 30th, 2021.
Second.
All in favor?
I move to authorize the hiring of the following individuals to the position of recreation attendant within the Recreation and Parks Department for the 2021 camp season as the rates indicated effective June 30th, 2021.
Second.
All in favor?
Listed below, sorry.
Aye.
I move to authorize the change in pay rate for Maria Roll to $20 per hour effective June 30th, 2021.
Second.
All in favor?
Aye.
Lisa?
No. Oh, yeah. Good. 6.
We're not doing number 5?
No.
6.
Thanks.
So I want
All right, whereas on May 25th, 2021, the town authorized the acceptance of contracted price extensions with Montesano Brothers, Inc. in New Rochelle, offered until July 13th, 2022, as per DPW 2020-04 awarded July 14th, 2020. Whereas the Commissioner of Public Works has requested authorization to issue a purchase order to Montesano Brothers for $1,223,870.79 for road paving for 2021 pursuant to the contracted price extensions. And whereas the funding breakdown of this blanket amount includes the $900,000 allocated in the paving line and New York State DOT allocated funding for 2021 to 2022 fiscal year of $445,886.93 from the CHIPS fund. Now therefore be resolved, the town board of the town of Newcastle hereby authorizes the purchase of paving services from Montesano Brothers, Inc. for 2021 road paving for the total amount of $1,223,870.70 per DPW 2020-04.
Second.
All in favor?
Aye. I move to authorize the Commissioner and Assistant Commissioner of Public Works to accept on behalf of the town the proposed high bids for vehicles and equipment posted on the Auctions International website.
Second.
All in favor?
Aye.
Do you want to take the last two, Laura? You want me to just do it?
Well, the last one I think we're not doing, right? That's the.
Oh, yeah.
So, that one,
All right, you wanna take the last
one?
We are doing the public hearing.
Sure.
Oh, yeah.
I move to authorize the purchase of materials and engineering services for the restoration and instrumentation for the Whippoorwill Water Storage Tank from NSC Systems for the total amount not to exceed $15,600.
Second.
All in favor?
Aye.
We're gonna set a public hearing.
This one is to schedule a public hearing for July 13th at Town Hall for the proposed local law opting out of adult use cannabis retail dispensaries and on-site cannabis consumption sites.
So moved, as described by Nick and is printed on this piece of paper.
At 7
o'clock.
7 o'clock or soon there's.
Great. Second.
All in favor?
Aye.
Move to adjourn.
I move to adjourn.
Second.
All in favor?
Aye.
Thank you,
Thank you.
everyone.
All right.
Bye, Lauren.